All right, let's start talking about some legal content, specifically the intellectual properties. This week I'm going to cover snapshots, overviews of patent law, trade secrets, and trademark law. And next week we'll do the right of publicity and then start the introduction into copyright. This isn't going to be full-fledged. You're going to learn everything about patent law, trade secret, trademark, and right of publicity. However, as I move along, you'll get a little more of each. I believe right of publicity, then trademark play a bigger role in affecting copyrights or being confused with copyrights than trade secrets and patents. So little snippets is where I see they'll fit in, and I'll tie it in so you'll know and to look for it, and I'll continue to pull those in and distinguish throughout the course. So that's my thought when I'm giving you this little introduction, because you're like, hey, I'm taking a copyright class, we're going to talk about patents, but I think you need to know a little bit about these so you can distinguish and fully get an understanding of what copyright law is, or copyrights are, and what the copyright law protections are. So patent law. This is, for a little background, lawyers who want to practice patent law have to get a special license and have had a scientific background before you can, which is unique to other practices of law. Generally, you can go to law school and pass the bar and then pick an area of law you want to specialize in or work in, one or two different ones, or three, and do your work. You learn and you get educated. But patent law is a little different. You have to have a scientific or an engineering degree or background, and then there's some specific other hoops you have to jump through. So I say that as a disclaimer because I don't have any of that. I just know what I need to distinguish for copyright law in the patent world, and I'm going to give you that little snapshot. So what is a patent? It is a right granted by the government that allows an inventor to exclude others from practicing his or her invention during the term of the patent. And in the last 20 years, court cases, litigation has skyrocketed in this area. Why do you think that is? Why might you think that is? Because we are in, a technological time. The industries of robotics, biotechnology, financial services, information technology, communications industry, pharmaceuticals is just growing at an extreme rate. And this is where patents come in. And companies view patents as technological tools. They're assets to their company. When they have patents, what can you do with a patent? You can license it to other people, and it has the potential to generate a lot of money. They are hard to secure. They are more difficult to maintain, and they have a very short duration versus copyright. However, they are the most powerful form of protection over a copyright, and here's why. Social benefits. It gives the inventor a few things: a reward for their invention, and it encourages others to invest the time, effort, and resources in developing inventions, getting that patent protected. Some people go out and get investors. It encourages investment in scientific and technological development, and it gives rights to exclude others from that. Promote business disclosure of inventions, which in turn stimulates further innovation and economic development, because this is made public. Your patent is made public, and I'll show you that's going to be part of your assignment. It's made public once it's granted. And why is that a benefit? Because someone can see it and say, hey, that's a great idea, but what if we did this? And they can expand on it, okay? So those are the social benefits. distinguishable from what benefits will come from copyrights, and we'll talk about that. Key point. This is a key point on patents. Patent is the only form of intellectual property that we are going to discuss that is dependent on the government awarding it. You just don't get it. You don't just get a patent. So in a copyright, you get a copyright once your art is fixed in a tangible medium. You get a trademark once you use it. When you have a trade secret once you start keeping it secret. So patent is the only one where you have to ask for government permission to get. They're the ones who award it, and I'll tell you how. Let's do a little background of where it's come from. So how long have patents been around? The first true patent system emerged in Europe in 1474. France, Germany, Netherlands, and England in the 1600s. The United States adopted the first patent statute in 1790. After the American Revolution, the states continued to issue the patents, but conflicts had occurred, and then the drafters of the Constitution gave Congress the power to start issuing patents, i.e. to promote, we saw that already, to promote the progress of useful arts by securing for limited times to investors the exclusive right to their discoveries. So the first patent in the U.S. was adopted in 1790. The application for a patent is reviewed by government officials, and they determine, before they give a patent, they determine whether or not the invention was before known or used, and whether it was sufficiently useful and important. That was their rule. That was their statute. And it developed, but I want to tell you the first patent that was issued on July 31st, 1790. The U.S. granted its first patent for an apparatus and process for making potash and pearl ash, and it was signed by George Washington. Basically what that potash and pearl ash, I had to look it up and see what that actually was. It's plants that are soaked in water in a pot, and it's used for a means of manufacturing various and mining salts, and it also contains some level of potassium. And that was what the first patent was. But in 1952, the Act was amended, and that's what we're dealing with now, the current Patent Act. It is, you can find it at the U.S. Patent and Trademark Office. They are the ones who are responsible for reviewing applications and granting patents, and that's where I'm going to send you to for one of the assignments this week. There will be two to visit the U.S. Patent and Trademark Office. You're going to look for a trademark and a patent. The duration. Once granted, how long is the duration of a patent? An issued U.S. patent will allow an investor or an inventor to exclude all others from making, using, selling, or offering for sale and importing into the U.S. for its invention that it is offered or it gets for a patent application for 20 years. So if you are an inventor and you apply for a patent and you apply on December 1st, 2019, let's say you applied December 1st, 2019, and the Patent Office reviews your application, and we'll talk about what constitutes the review, what's needed in it. And then it says, yep, you're getting your patent, and they grant it to you, but you don't get it granted to you until April 1st, 2020. Your patent date, your 20-year patent that you have on that is measured from the date you filed, not the date it was issued. So the date you filed. So December 1st, 2019, and 20 years. There's no renewal after that. After that, where do you think it goes? Public domain. And we'll talk a little bit more about the public domain because it relates to all intellectual properties. Everything that isn't protected goes into this, I feel like it's a void, public domain. There is no website, hey, this is the public domain. It's it's like an abstract concept. Anyhow, let's delve into our types of patents. There are 3 types of patents: one that's called plant, one that's called design, and the one that's called utility. Utility is the one we were all very familiar with. That is the one we're going to talk about, but I'm going to tell you about the other 2. The class of utility, it's the most often referred to when patents are discussed, like I said, and it's the most important for the economic standpoint. Plant patent, it's available to those who invent, discover, or asexually reproduce any distinct and new variety of plant. Design patent protects new, original, and ornamental design for an article of manufacture that results from manufacturing process. It doesn't contain moving parts. It protects visual appearance of a product as a whole. An example of this would be the sole of an athletic shoe. Okay, I think for purposes of this class and how it relates to copyrights, the one that we're most familiar with, the utility patent, is the one that we are going to discuss and that I want you to be familiar with. So, how do you get one? All right, how do you get a patent? Obtaining a patent. First, you need an invention. First of all, this concept of getting it, going through the process of getting it, it's called the patent prosecution. Sounds like a court case. It sounds like somebody's, on trial for some sort of crime. A patent prosecution. That's not what it is. That's the process of getting your patent. So what's the first thing you need? First thing you need is your invention, an actual functioning prototype. No ideas here. Hey, I got this great idea for an invention. That you have to develop it, okay? Once you have a working version, has to be working, you are ready to apply. So the process, so this is what we're talking about with we're talking about a utility patent. Whoever invents or discovers any new or useful process, machine. Oh, okay, let me click to my next, so you can follow along what I'm talking about. Utility patent, this is what we're talking about. This is when you get one, you have to have all of these elements. Utility patent. Whoever invents or discovers any new and useful machine, manufacture, or composition of matter, or any new and useful improvement thereof, may obtain a patent, therefore, subject to the conditions and requirements of this title. That's the fancy rule for you getting a utility patent. So what's the first thing you should do before you even apply? You should probably conduct a search for your invention to make sure one doesn't already exist. And there's a link. This is going to be part of your assignment, is I'm going to have you look for a patent. So if it's not there, or when you go to do, take a side note, when you go and do this part of the assignment, review the application process. It appears to be quite involved. What you'll notice is what you need: a description, photos, drawings, descriptions. All of those things are contained in a patent, and it consists of 4 parts: a summary with drawings, your claims at the end of the specification, what you claim it does, an oath saying that you've actually invented it, and then there's some filing fees. But you take a look at that. We're going to go through the details here, and I have some folks that are out mowing the lawn. There are 4 requirements to qualify for a patent. Those are: your invention must be of a type of subject matter that may be patentable. We'll talk about each one of these in detail. It must be useful, it must be novel, and it must be non-obvious. So let's break these down. There's this little chart that the patent office goes through. The first thing they look at is the invention a subject matter that we grant patents for? And if not, boom, they just kick it out. It doesn't go to the next step. And then so they go step by step by step all the way down. And if in the end your written description of what it is adequate, meets those things, then you'll be awarded a patent. So let's talk about the specifics here. The subject matter. Now the subject matter has to be one of these few things here. If it's not, then you don't get a patent. So you have to have a new and useful process, or it must be a machine, or it must be a manufacture of matter, or a composition of matter, or a new and useful improvement. So I'm going to take one of these bit by bit and give you an example. Process is a method or procedure presenting a series of steps or acts for achieving a specific result that carries out a specific task. For instance, the method for producing stainless steel. The procedure used to measure the level of acidity in soil. The technique used for cloning genetic DNA. So a new and useful process can be patented even if the results is a known result or in a known product, meaning it already exists, but you're doing it in a different way. You can have more than one method to achieve the result. It's the method that has to be subject to the patent. Okay. The next one is the machine. So we either have a process or we have a machine. This is the one most people are familiar with. An apparatus or mechanical device composed of moving parts that perform some function and produces some result. Computers, right? Car engines, clock radios, iPod. Those are all examples of a machine that meets the subject matter requirement for a patent. Manufacture is any product or article made from raw materials. That's the key component here. Raw materials that result from a manufacturing process and that does not contain moving parts. So it doesn't contain moving parts. It's the result of a manufacturing process, like it's made, and the materials are raw. Okay? Plastic cup, a chair, tennis racket, baseball bat. Okay? Composition is a mixture or combination of substances or elements. Think of an example of those: chemicals, powders, gases, pharmaceutical drugs. Those all are subject matter that's under composition, the composition component of subject matter. So that's what your invention could be. Or improvements. It's kind of like the catch-all. And it's based upon any of the above inventions, even if the underlying product is in the public domain. So if you improve upon any of something that is already has a patent or in the public domain and you improve upon it, you can apply for a patent under the subject. And we got the subject matter. We still got to meet the other elements, but you got the subject matter component. You're saying it improves upon an already created invention that has a patent, or it's in the public domain. Why have this? Because they're follow-ons to inventions, and they enhance and they build upon pioneering. We create, well, that's a great idea, but what if we do this, or if we expand on this? So allowing for improvements, the ability to get a patent on improvements is obviously helps society. So now that we talked about what is a subject matter, let's talk about what is not subject matter. There are 6 categories. I don't have slides on those, so you might want to keep track of them. Things that are the product of nature, such as a newly discovered natural organism or mineral or chemical element or a new plant found in the wild. Product of nature. Something that's a product of nature is not subject matter to a patent. Laws of nature. Gravity, right? Or Einstein's EMC squared? E equals MC squared. Relativity, is that relativity equation. Not a math person, not a science person. Natural phenomena, volcanic eruptions or tides, mathematical formulas. Abstract ideas are not. Mental processes, like the way the human mind thinks, that is not. Those are all not subject matter to patents. Why not? Well, our Supreme Court said these are basic tools that are part of the storehouse of knowledge. These things have existed, so they are freely available to us all to use. So the key to identifying patentable subject matter is the element of human creation and invention. So the point is, the process used to discover them might be patentable, but those things themselves are not. And if we were in a classroom, I would be splitting you up in groups and giving you some patterns to work through. But those will be part of assignments to do. So, subject matter. Let's talk about the next component. So you meet subject matter, but your invention has to be useful, because that's what the Constitution says. States right in there. The Constitution grants Congress the power to grant patents for discoveries in the useful. Okay? What's useful? If it's capable of providing some identifiable benefit that is both specific and substantial. Oh, those are two words there now that we have to define. And this is our useful definition. The proposed utility must be specific to the invention claimed rather than a use generally applicable to the broad category into which the invention falls. And it must not be so vague as to be meaningless. So it has to be specific, and it has to be substantial, meaning not so vague. So let's specific. Specific is the device that that's an example of specific. Specific is the proposed utility must be useful, has some sort of usefulness. It must be specific to the invention claimed rather than the use generally applicable to the broad category. I already gave you that definition of specific, so let's talk about specific examples. It is specific when you say your invention is a device that records high altitude atmospheric temperatures for the use of predicting weather patterns. Right? That's pretty darn specific. Here's your invention. This is what it does. But if you say something like, as opposed to, it's for meteorological purposes, or I'm going to use it as a landfill, or I'm going to use it as a paperweight. It's not specific enough. Okay? Has to be specific. So if you have an invention, it slows down or gives an intermittent pause to wiping rain from your windshield. Might be an example of the intermittent windshield wiper, which, by the way, was a very sought out invention by Ford. They made a movie about it. It's Flash of Genius. It's called Flash of Genius. It was about how Ford stole a patent from a professor who created that invention. So if you're interested, I think you could probably find it free on one of the streaming apps. And if you're interested, to give that a look. Substantial. Has to be substantial. Has to be operable. The key here to substantial, meaning it's got to exist. It has to be operable and provide a presently available real-world benefit in its current form. Okay, so as long as the invention is capable of performing its proposed function, it need not be the best, and it need not be the only way of doing it, nor does it need to be capable of commercial success. It just has to work and have some sort of real-world benefit. That's what makes something substantial in the patent world. So those are the points, okay? Need not be the best, need not be the only way to do it, doesn't need to be capable, it just needs to be specific. It has to have a specific point, and it has to be workable and provide some real world benefit in its current form. Novelty. So we meet that test. We go to the next one. Novelty. Invention must be new in order to be patentable. If an invention has been patented already, if it's been described in a printed publication, in public use, on sale, or otherwise publicly available anywhere in the world before the date on which the patent application was filed, you do not get a patent. Why is that? These situations are deemed disclosures. And if you do it before the date of your application being filed, they're considered not novel. They're already out there, right? Novel. So I just want to break down my little list that I just do. Patented. If it's been previously patented, you can't get a patent, okay? It's been done already. Printed publication that discloses the same invention. You actually have 1 year from the date of publication. Actually, this is my list. I just read the list. The next one, patented. We just talked about it. I'm sorry. If it's patented already, then you don't get to patent another one, or because somebody has it, or you've already done it. So, printed publication is where we are at. So if your published disclosure is that the application for the patent must be done within 1 year. So here's my example. There's a chemist who is eager to share his discovery. He writes and he publishes in the American Journal of Applied Chemistry an article describing a particular compound, and 2 years later he applies for a patent. Unfortunately for him, his application will be denied. This would be true even if another person had done so as well. Let's say somebody else read it and said, "Ooh, let me go patent that." He can't go back and say, "Hey, that was mine." Nope. Once it's printed, it's in the public domain. If somebody else tries to patent it even 2 years later, nope. Okay? So, I don't know why anyone would want to print about it, but maybe there's some benefit doing so. But you have 1 year to get that patent in place, otherwise you lose it. Some examples of printed publications: journal articles, dissertations, in books, of course, even in advertisements, web pages, online newsgroup postings, technical reports. All of those things will constitute a publication if it contains the description of the invention. So if it contains the description of the invention and is considered published on the date it becomes publicly accessible and made available to persons who might be interested, and this includes even a single copy. You have 1 year to file for your patent. If you don't, it's gone. You don't have that opportunity. So, because it loses its novelty. Publicly accessible and made available to persons interested. Oh, I already just said that. And a single copy is good enough to be considered publication to take it out of the 1 year requirement to file for a patent. Public use in the United States. If already being used in the public or available for use in the public, even if used only once, or if the inventor makes available for use or the inventor has used it in public. If it's the inventor who has used it in public, they have 1 year to apply for the patent. But in any of those other circumstances, that's a bar. You don't get to apply. It doesn't make it novel. The inventor's commercial use or exploiting for commercial use of that product can lead to it being barred. So you don't want to offer it out there. And this is here's a good example, because I think you'd all be familiar with it. You guys remember, I don't even know if it still exists. I haven't seen it in a while. But those Dippin' Dots ice cream things, there's the little ice cream balls, and they call them Dippin' Dots. You see them in the mall, and maybe at fairs or festivals, they still have them. When they were first coming out, the owner would go to festivals and distribute their samples out. Sometimes they'd offer them for sale, but they were putting them out there. They never went to get a patent, and somebody else attempted to use their product. So they said, "Hey, that's our product," and then they went and applied for a patent. They were denied their patent. So, and that's just a very general discussion of how that case went. It was a lot of technical information involved, but it turned on public use. They were putting it out in the public already before they applied for their patent on that ice cream, or whatever it's called. I don't even know if it's called ice cream, but that something that we ate, and it was really good, and it tasted like ice cream. On sale. Oh, wait, what if you use it for your personal enjoyment? If you're the inventor and you use it for your personal enjoyment or in secret, then it's not considered public use. But I would get it patented if that's your intent. On sale. If it's sold, even one unit, offered for sale in the U.S., you are barred. Oh, I'm sorry. If it's sold, even for one unit, you are barred. If you offer it for sale, but it's not on sale yet, you're like, hey, I got this great invention. It's almost done to be put out in the commercial, to be sold commercially, but I'm offering it for sale, but it's not out there yet. You have 1 year to apply for your patent if you're making offers to sell. Okay, but the key point of this is at the time of the offer, the invention must be complete and ready for its patent. Must be ready to go. Remember that. It's got to be existing. And the terms of the offer are definite, meaning this is what it is, this is what it does, and if you're buying it from me, I'm not going to go into details because this is not a class for details of what the terms have to be. The point is, your invention's not novel. If you're offering it for sale and you haven't applied for your patent, you're going to lose the novelty if you don't apply for your patent within the 1 year. And available to the public. Okay, this is the catch-all category, includes all publicly accessible knowledge, including oral disclosures. If you make it available to the public and this applies worldwide, you can be barred from getting your patent, the catch-all category. Okay, you're going to ask whether the actions taken by the inventor created a reasonable belief by the public that the invention is freely available for use. And some examples of this is if you demonstrate it at a trade show, you lecture or do an oral presentation about the invention. Maybe you make a disclosing statement about the invention and talk about it on a radio talk show. You make a YouTube video about it. You got it on a website. Does not have to actually be used by the public. It just leaves the belief that it's available to the public. Okay, so the moral of the story here is file your application and then talk about your invention later. Get it done. I mentioned the movie Flash of Genius on patents. That's a pretty good movie if you got some time and you're a movie buff and you haven't seen it. If you're a podcast buff, there is, on NPR, there's a podcast called How I Built This. I love that podcast, one of my favorites. And there was a woman who created an item of it's a type of women's undergarment. It's called Spanx. I won't go into the details here on this lecture. The ladies probably know what it is. Maybe some of the guys do. But in that podcast, the interview with her, she goes in great detail about how she went about obtaining her patent, which I thought was pretty interesting if you want to follow up with that. All right, the last component, non-obvious. It must be non-obvious in the sense that it represents an inventive breakthrough, a next step, meaningful advancement, or a leap forward in the field as measured by the differences between the invention and the prior artwork, invention, whatever that might be, whatever you're doing. And the point of this is it prevents an invention that is new, yet merely routine. Not obvious. I mean, novel is new. You might get over the hurdle of newness, but if it's routine, If it's predictable, trivial, then you might not meet this step. Only true innovations are eligible for patent protection. And the question is whether the invention would have been obvious to or easily conceived by a person with ordinary expertise and knowledge in the pertinent field. Okay. I don't want to delve into like the details of this. I want to give you examples because I just told you it can't be non-obvious. It has to be meaningful in the advancement in the field and an inventive breakthrough. And one of the assignments you're going to do today or this week is to look at different patents that might be out there. And you might come across some pretty remarkable things, and you might come across how did that meet the 5-factor test? And just to pull out some that I've seen that were awarded, these were awarded patents. Pizza box, a patent for a pizza box. There is a patent for the method and system for identifying people who are likely to have a successful relationship. There is a patent for the method of exercising a cat, and the description is you use one of those light beam pens and flash around on the floor, and your cat tries to chase it. That's the description. I paraphrased it, but that's the description. There's a patent for putting a golf ball. And there was big litigation on a patent that was applied for, and it was described as a system for disseminating media content representing episodes in a serialized sequence. Does that remind you of anything? How about podcasts? Because that was the intent. The person who filed for that patent was an attempt to get a patent on podcasting, and if that was success, and there was a lot of people who challenged it. If that was successful, actually it was a patent. It was granted, and then they tried to collect on sending letters to people saying, "Hey, we own the patent on podcasting. You got to pay us the licensing fee." And people got together, especially large organizations that do podcast things like NPR and iHeartRadio. They brought a lawsuit, and the court system basically distinguished the patent and said, "Oh God, no, that doesn't even meet the non-obvious." So the point of this part of the discussion is there is patent trolls that will file for patents. They're very creative in completing the application process. And then they get there's all sorts of crazy ones out there. And then they try and make money. They call them patent trolls. So anyway, that's our discussion on patents. We'll move into trade secrets next.